Hello, everyone. We are going to give everyone another 20 to 30 seconds to get into the room. If you haven't already left a message or a comment with a question that you've got, then please do so. I am able to see them. I see additional questions coming in. We've got a good number of topics to go over today. To get started, I thought that we would go through and let everyone introduce themselves first. And we'll start with Austin Bersinger, who is an attorney that I've used and I trust anytime I have a question about insurance law. And so I'm going to let Austin tell us a little bit about his background and credentials and why you should listen to him. So go ahead, Austin. Austin, we can't hear you, buddy. Let's see. How about that? Yeah. Looking good. Nope, not anymore. So what we'll do is we'll go to Sheri for right now, and Sheri, you can introduce yourself. Sheri is an employment lawyer who primarily represents employers and is someone that I've come to anytime I have questions. A lot of the questions that I've got are employment related, and as a result, I don't know a lot of those questions. I mainly handle personal injury cases, and so I asked Sheri to come on and talk to us. Sheri, I'm going to let you introduce yourself now.
Thanks, Matt. So I'm Sheri Oluyemi. I am a solo law practitioner of the law office of Sheri Oluyemi. I advise employees as well as employers on the full gambit of employment-related issues. I've been doing this now for several years. Here in Georgia is where I'm based. I'm also licensed in New York, as well as in Ontario, Canada. Most recently, I was interviewed by WSB TV regarding the COVID-19 issue, and I'm happy to be here to answer your questions about how it's impacting your workplace and your community.
Absolutely, fantastic. All right, Austin, how are we looking now? Bad. We're looking bad. See if you can get you up and working. Let's see, I'll make sure that you're not muted on our end. And while he's playing with that, so my name is Matt Wetherington. I'm an attorney. I primarily work with young professionals for personal injury or wrongful death or class action claims. A lot of the questions that people are having about COVID, I don't know the answers to, just because that's not an area of law that I practice. And so I thought it'd be helpful to get the people that I know and trust and turn to for answers to come in and help us out. And so what we'll do is I've got probably 25 or 30 questions, and I'm going to try and get through everyone's questions here. And Austin, maybe it just came on? Negative. All right. So the first question that I wanted to ask here, and this is one that we got the most, is, and this one's going to go to you, Sheri, is an employee required to keep working during the pandemic? So let's say that I don't have any symptoms, I don't have any kind of problems, but I'm scared just generally of going to work. Am I required to go to work? And if I don't go to work, what are my legal options?
Well, that is a common question we've received. So can an employer terminate an employee for just failing to show up? The question is a typical lawyer answer. It depends. So you have to ask why the employee is not attending work. If the employee is not attending work because they are refusing on the basis of OSHA, which is the law that protects employees from unsafe workplaces, then you have to find out whether they're refusing to work on the basis of believing that there is a dangerous workplace. Now, OSHA has a broad definition of what a dangerous workplace is, but there are various steps that the employee has to take to establish that they are refusing to show to work on the basis of OSHA. So they have to tell the employer what the concern is. They have to assess whether a reasonable person would think this is a concern, and they have to give the employer an opportunity to remediate the issue. In something like COVID-19, where there's not enough time to wait around for an OSHA inspection, it's fairly safe for an employee to refuse the unsafe work and wait at the workplace until the employer determines what they're going to do. You also have to ask the employee if they're not attending work because of the ADA. So the EEOC, which is the government agency that enforces the ADA, has determined that generally COVID-19 is not a disability, unless of course your symptoms are to the level at which you're hospitalized. But generally it's akin to the flu, so it's not considered a disability. But if an employee has an underlying condition that is a disability, and thus they're refusing to attend work because of that, The employer does have a duty to engage in the interactive process to find out whether there is an accommodation that could allow the employee to refuse work and still keep their job. So all that to say, you can't necessarily fire an employee for refusing to go to work. You need to ask them why. And if they don't have any valid reasons under OSHA or the ADA or any of the other acts, then absolutely, they're required to keep working. Oh, I think I've lost you now, Matt. I can't hear you.
So I got some requests to mute the microphone so people can hear you better. So I'm gonna bear with me as I kind of bounce back and forth. I think I've got it fixed. So Austin, how about you? We got you now?
I think we do.
All right. So first, tell us who you are and why we should trust you.
Sure. My name is Austin Bersinger, and I own an insurance recovery law firm in Atlanta, Georgia. My expertise in practice is specialized strictly to policyholder insurance coverage. So that means that my job is to help businesses and Georgia companies get the insurance coverage they paid premium for. So half of it is counseling businesses on the front end on what their insurance needs are, making sure they've got the right coverages. And on the back end, when an insurer attempts to shirk their responsibilities or deny coverage unreasonably, I get involved and help the insured or the business really get what they paid for. And if it gets unresolved, then we proceed to litigation against the insurance carriers. So that's kind of what I do now. My experience before that was at a very large law firm working for the insurance company. So I'm kind of in a unique position to do this particular practice because I've worked for the insurance companies. I know how they think, and now I'm representing Georgia companies to help them get insurance proceeds.
All right. So number one question that I've gotten for you is twofold. One is what types of insurance will provide coverage for COVID? And then number two is for those of us who, like me, who are now learning that we don't have insurance that covers some of these losses, what kind of insurance do we need to purchase so that we actually can have those losses covered in the future?
Sure, that's a very popular question right now. And I think the bottom line is that you need to check all of your policies. So we've seen a lot that commercial property policies, so policies that business has is like to protect their actual physical structure, usually from hail damage or from wind, but it also applies at times for bacteria infections, government shutdowns within the building, the physical structure. And so what I would tell you is that one very common place to look is going to be property policies, because property policies oftentimes include your business interruption, and your business interruption claim or coverage is there for times exactly like this, where an external unexpected force has come in, a global pandemic, and made it so that you need to be compensated for the loss of business. If you're a restaurant, if you're any kind of business, you have these losses. So that's kind of your first place is property. Your second policy that every Georgia business is going to have is commercial general liability policies, and they may, in some circumstances, help kind of mitigate these losses and provide coverage. What I would tell you is that with insurance coverage, it's incredibly detailed. It's always directly related to what your policy actually says. These are contracts, and a lot of times these contracts are worded slightly differently. But that difference in wording can be the difference from getting coverage and from having a carrier successfully deny coverage. So really, for most businesses, it's going to be your property policy and your commercial general liability. And then there's a couple more specialized policies that I can get into, but I think that's a good place for most businesses to start.
All right. So two follow-ups. You mentioned property insurance. All right. So I have property insurance for my home. Are you talking about that kind of coverage? Like, would I be able to recover for coronavirus from my private home property insurance?
Without seeing your policy, I would tell you that I don't want to say the answer is no. I want to tell you it's unlikely. On the business side, business property policies are a little more built out. They actually really intend to cover more perils and additional risk than a homeowner's policy probably would not have the breadth or scope of coverage, but I think it's definitely worth a look.
Okay. All right. So now I'm going to turn back to you, Sheri, and this is the second most popular question that was asked, and that is, All right, so I'm an employer or I'm an employee and I refuse to show up. Can that person be fired? And if so, are there any consequences either for the employee or for the employer?
So, as we talked about a little bit earlier, the employee cannot necessarily be fired every time. So, it is a fact-specific inquiry you need to engage in with the employee. Why are they not showing up? ADA, OSHA, any other claims they may have, you need to discuss that with the employee. And if they do not have a valid reason, then generally, yes, they can terminate. So, the key to that question people are asking is, well, I don't want to work on a floor where I know that there are people who have COVID-19 symptoms or COVID-19, the disease itself. So can an employer force me to attend work when I know that some of my coworkers have the disease or have symptoms? And it takes us back to OSHA primarily because that law has a general duty clause, which requires employers to protect employees from danger. COVID-19 has been determined to be a pandemic. So we're pretty sure it fits the bill. So the employer now is under a duty to protect employees from that danger. That duty, I would opine, does require the employer to consider whether asking an employee to work on the floor is safe. I mean, as a practical matter, it's probably safer to ask that employee to telework if possible. OSHA also protects employees from retaliation. So if your employee is refusing to attend work on the basis of an OSHA complaint, you can't turn around and terminate that employee for having made that complaint. OSHA is one of many employment laws that protect employees from retaliation. So I think I've answered that question, Matt.
All right, so follow-up question that, what if I don't even know that the person has COVID? I'm just generally scared. So like we know that, for example, in Georgia, there's not enough test kits. We know that the numbers that we're receiving publicly aren't actually what is the reality. So some people have COVID or don't even have symptoms and don't even have symptoms. Do I have to show up to work if I'm just generally scared and I don't have actual knowledge of someone with symptoms or that actually has a diagnosis?
Okay, so your fear has to be reasonable. OSHA does require the employee to think about whether the refusal to work is something that a reasonable person in that same circumstances would do. So the ADA has the protections for employees with regards to their confidential medical information. An employer is not entitled to just announce to everyone that Joe Blow had COVID-19 and that's why he's at home. So the employer is not going to make that announcement. More than likely, the employer would say there is a risk of exposure here, or there has been some exposure, and therefore we're taking the following measures. If the employer makes that type of announcement, then it's more likely that the employee's refusal is more reasonable. Or if the employee is working in, OSHA has determined that workplaces are divided into high risk, low risk, and moderate risk. If the employee is working in a high-risk environment, such as a hospital, then it's likely that the employee, even without knowing for sure that there are risks or without having any positive tests, it's more likely that that refusal would be reasonable. So once again, it's a specific inquiry.
All right, so this sounds terrifying. So it sounds like we're really in a place where I might end up working next to somebody who has COVID. They have no symptoms, but I may not have the full legal remedies that might be available to me if, for example, that person is coughing and is actually sick.
Exactly. So you wouldn't be safe just to go home and say, I'm scared and I'm just not coming to work. An employer could may be able to terminate. So that is a risk that I don't recommend.
Okay, that sounds terrifying. All right. So the other question that we've gotten a lot is, so let's say, for example, I do go to work and I'll take this one. So I go to work and someone actually has COVID and they knew they had COVID and they come in contact with me and they don't self-quarantine. Can someone file a lawsuit against that person? All right, so this is getting into the area of torts and personal injury, and I should stop for a second and make sure that I'm clear that everything that's discussed on here today is not legal advice. We're giving you general answers to common legal questions. Every situation is very different. There's a big difference between someone who, say, works at a restaurant versus someone who may work on a factory floor versus works in an office environment. Like, for example, I'm in an office right now, but I'm literally the only person here. There's different risks and different factors. So to answer the specific question of kind of what can happen if someone actually has COVID, doesn't self-quarantine, and then goes out into the public, the answer is maybe. So let's say, for example, that you've got a person who knows they have COVID, goes to someone who had a previous negative test for COVID, and they then get a positive test after coming in contact with this person. And this person knew that they had COVID, and the person actually develops symptoms and has to go to the hospital or gets damages. In that situation, there probably would be some sort of civil lawsuit that you could file for the medical cost and the general pain and suffering related to getting COVID. But if someone just comes and puts you at risk of getting COVID and you don't actually get it, then no, there wouldn't be any kind of civil lawsuit there. And these questions are flooding in here. All right, so Austin, so my business has commercial general liability insurance. Will that provide coverage? So first, tell us, for people watching, what is commercial general liability insurance? And then second, will that provide coverage for COVID to business owners?
Definitely, Matt. Well, commercial general liability insurance is the typical insurance that covers you for a slip and fall that happened at your business, or if a tree fell down and injured someone on your business property. Now, that's kind of thing we're thinking about. Also, if there was different construction and you're a contractor and you had some defective construction or some resulting damage, that would cover that kind of loss. So that's primarily what commercial general liability insurance is. I would say 99% of businesses are going to have it. Now, a lot of businesses are mandated to have it under state law. So the issue is whether this type of insurance is going to cover it. And it's definitely policy language dependent. In this case, it depends on whether the exclusion for bacterial infection or viral infections is included in the policy. Now, there's a large insurance body that kind of comes up with the forms. And in 2006, they started to include a viral bacterial infection exclusion in most policies. Now, that being said, it's not in every policy. It's not in every carrier's policy. So the first thing you've got to do if you're a business in Georgia is read your policies and know what risk is covered.
What if they don't even have the policy though? How do you even get the policy to begin with? Because most people get this in the mail, put it in a filing cabinet, and have no idea where it is. Can they get that policy to read it somehow?
They can definitely get the policy. Now, a lot of times you can't get the policy from just calling up the insurance company, and they'll tell you, well, you got to call your broker. So the first thing I would tell you is that you probably used a broker, a producer, or a wholesaler when you got your policy. So your broker is kind of like X insurance agency, and you called them up and you said, hey, I need this insurance to start my business. And they said, okay, here's some options. Call your broker, call the insurance agency. They're going to have it, and they can get you your policy. I mean, you're definitely entitled to a copy of your policy.
All right. So, okay. A couple of different people have asked this question a couple of different ways. All right. So, can the employer force you to work on a factory floor or a retail floor with people who are at least symptomatic but don't know for certain that they have COVID? Ooh.
So, like we said, generally an employer can not force you if you make the right objections. So you state that I'm refusing to work on the basis of unsafe work conditions. This is reasonable. I'm going to stay on site till you figure it out. In that case, the employer would not be proper for the employer to work. Let's talk to make you work. Let's talk a little bit about being a practical matter. Given as highly infectious COVID-19 is, employers have to consider whether they want other employees in close proximity with employees who have symptoms or who have indications that they could be carrying the COVID-19 virus. If your entire workplace gets infected, what's that going to do to your bottom line and your productivity? So even where the law strictly does not give you the protection you need to consider about a practical matter, whether you want that sick employee on the floor or you want other healthy employees in the workplace with that person at all.
Okay, let's just presume that I'm a terrible boss and that I am a jerk, just generally a jerk. And it's more important to me to make money than it is to protect the public or protect my employees. and I force my employees, and my employees are rightfully scared of losing their jobs and are rightfully concerned that if they don't go to work and potentially get infected, that they're going to lose their job. Does the employee have any legal recourse on the back end if A, they do in fact catch COVID, or B, even if they don't catch COVID, just for being forced to work in that kind of environment? Like, is there any legal recourse?
Well, yes. So the employee can either file a workers' compensation claim if they actually catch COVID-19. The only issue with that I foresee is that the workers' comp requires the injury that is covered to be contracted at work, and it requires that the opportunity for exposure be limited to the workplace. So it'll be very difficult for an employee to establish that they didn't contract COVID-19 on the way to work, at the grocery store, etc. So that's going to be an evidentiary hill for the employee to cross, although they can bring that claim if they can definitely demonstrate that they got it from the workplace. Another claim that, like you said already, with regards to torts is negligence. The CDC has released extensive guidelines for employers about this. So has the WHO, so has OSHA. The employer should be doing everything in these guidelines in order to protect their employees. If the employee can demonstrate that the employer did not take all reasonable precautions, then that is potential for a negligence suit, especially if the employee actually catches the virus and can exhibit those damages.
Okay, I'm hearing a lot of sadness for employees, and that's okay. I mean, it is what it is. So let's say that I'm a business owner and I'm wanting to actually file an insurance claim because I've got some sort of tangible losses. What are the steps? What are these? Are insurance companies still working? Can people still make claims? And if they can make a claim, what do they do? And this is going to be to you, Austin.
All right, thanks, Matt. Insurance companies are still viable companies. They are still accepting claims. As of last week, there were over 10,000 claims already made. So here's the takeaway. If you remember nothing else from this discussion, you should remember that you have to give notice to the insurance company. And the way you do that is you call your broker, you call your agent, and you say, I want to make a claim. And they'll say, okay, you need to fill out this form. That form really needs to be sent in within 30, 60, 90 days. I mean, you very, very punitive case law in Georgia if you don't tell the insurance company quickly about your claim. So what I would say, your first step is call the person that helped you procure the policy, the broker. Make your claim, document your claim. So what I mean by that is you need to be writing out, taking pictures of, if it's decreased traffic in your business, you need to say, we'd have 50 people on a Tuesday and we had 20 people because of this. Now, a lot of these statistics are going to be unneeded because turn on the news, everyone knows just kind of, experientially, this is having a pretty large impact. So what I would tell you is step one, notice your claim to your carrier. Step two, you need to make sure that you're writing out exactly how this is affecting you. So, you're going to have to go back to your business from year before, 2 years before, and show trends, for business interruption loss, at least. And then, for your property policy, you're going to have to show at some point that you had COVID-19 on your property and there was an actual either occurrence or that you had a viral or bacterial kind of swab or sample. So there's going to be like particulars to the claim itself that you're going to need to be mindful of after you make the claim. Now, what I'll say, Matt, is really the issue where it gets a little bit more interesting is, all right, you make a claim. Let's say Matt makes a claim under his business and he gets a letter back and it's the insurance company saying, we don't cover this. That is not the end of that's not the end of it. They don't get to claim what they're going to cover or not cover.
I would call you in this situation.
Hopefully.
So, but
what it really comes down to is the contract speaks for itself. So I think what I would caution people is the insurance companies, because of the incredible just breadth of claims, because of how big this is. I mean, this is the equivalent of a hurricane happening in every major city in the country at the same time. If you're the insurance company, so you're going to have a huge amount of claims, and they're going to want to say, no, we don't cover that. That's not the end of the game. And what what I want, business owners to think about and to remember is, you paid for this product, and you need to fight back. Don't just take their word for it in this instance.
All right. So short answer, yes, I agree absolutely with that. So a lot of people don't remember this, but there was a big earthquake in California a couple of years back, and what the insurance companies were caught doing, this isn't just a made up story, people went to jail for this, but they started forging earthquake waiver forms for claimants. So there's this waiver that basically said that, like, you agree that earthquakes aren't covered, and they would sign the form and they would not have that coverage. These people didn't actually sign the coverage. In fact, they had the coverage, but the insurance company and some of the brokers were actually forging these waivers to make sure that these people didn't get coverage. Do you think that that's something that we can see here in Georgia for people? I mean, because is this an explicit exclusion that can potentially be forged?
I think what I would say is that financial stress, and I think the economic downturn that we're about to see, will make companies act irrationally. It will make companies do, insurance companies in some instances, the wrong thing. And what I don't want to proactively say, yes, I think they'll commit fraud. But what I will say is this is the time to hold their feet to the fire and to really make sure that you're getting the product you paid for. So, this is not the situation in which I would just trust it and let it go.
Okay. Here's what I will say just to end that point is that State Farm ended up paying $3 billion in penalties for forging those documents in California. I can't imagine that we're not going to see at least some level of fraud from insurance companies in Georgia and everywhere else. And so if you're listening and you're getting those rejections, don't just take that as the gospel. To take additional steps. So turning back to you, Sheri. So I got a couple of variations on this question, and some of the questions that have come in are very super specific. And so our goal here is not to give you legal advice. There are a lot of ethical things that we got to be careful of in doing that. If you have a specific question about a specific question, reach out to one of us directly and we'll help you if you can. I'm going to kind of simplify some of the questions that are coming in. And so this one is just a basic overtime question. So, salaried workers that are working, they're having to work and they're being forced to come in and work more than 40 hours a week to cover for people who are sick or have COVID. Do those individuals have any kind of recourse if they are a salaried employee?
So the answer to this question is generally governed by the Federal Labor Standards Act. And when you say salaried employees, you're probably talking about those employees that are exempt from the Federal Labor Standards Act. So these are the employees that are typically paid salary and fit into one of the job classifications of the exempt employees. So generally, the Act does not limit the amount of hours that these employees can work. These employees do not receive overtime pay. The overtime threshold is 44 hours a week, and these employees are not entitled to overtime pay. So to answer your question directly, if by salary you mean an exempt employee, then absolutely the employer can require you to work extra hours to cover for those employees who are not at work because they're sick or because they're calling in sick, or for whatever reason they're not in the office, and you are an exempt employee, you would be required to work those extra hours, unfortunately, without additional compensation. But once again, as a business in a practical manner, a lot of employers have self-regulated so that they can keep their good, talented employees. So they won't work them around the clock, and they won't work them to the point that their hourly wage actually becomes less than minimum wage, because that would be illegal. A lot of employers just don't do that. But generally, the Act does not limit the amount of hours that you would have to work. Additionally, the Act does not limit you to your job description. So for instance, if you have a task that fits into your job description, and then there's an employee who is away sick due to COVID-19, who has a different task, a different job description, there's nothing preventing the employer from assigning you to that task. So the Act does not limit the employer to the tasks that they can assign you to do. There might be some limitations in your employment contract or in your employee handbook. Typically, a lot of employees are not employed pursuant to an employment contract. But barring those contractual obligations, the Act doesn't limit the amount of hours you can work, nor the work that you can actually do. So I'm sorry to be the bearer of bad news for employees today, but the Act in some states do give broader coverage. I am speaking with respect to Georgia and the federal sphere, but Georgia doesn't have any additional protections for employees in that regard. Oh, I've lost you, Matt.
All right, so one of the questions we've gotten relates to the legal deadlines, and so I think what you're referencing here is that, here, let's do this. So all of the Georgia courts were recently issued an order that basically said that certain deadlines are extended, certain deadlines are not extended, certain courts are open, some courts are not open. I can't speak at all to the criminal issues. I don't do any criminal law. So my understanding is that many of the criminal cases are continuing to move forward, especially when there's a constitutional issue, either to due process or to expeditious trials. On the civil side, there are two different courts. There's the state courts, and then there's the federal courts. The federal courts are kind of leaving that to individual judges to decide what they do and don't do. In the state courts, the vast majority of civil state court deadlines have been extended. That doesn't mean that courts don't have the discretion to hold hearings either telephonically or to decide motions based on the briefs. So some cases are moving forward. What I've noticed in my personal experience just in the last week is that some courts are actually getting to a lot more things than they normally would because they aren't burdened with the in-person hearings and the trials and things of that. So they've got a little bit more time to work on things. Other courts have just completely shut down and kind of nothing is moving. I've even had courts where we filed pleadings and they've rejected it and said, file it after the shutdown. So the correct answer to this question is just that it depends and it's court by court. And we're going to expect to see a whole lot of mess and fallout related to missing deadlines, not missing deadlines. And it's going to be a lot to kind of sort through. I'm going to go right back to you, Sheri. So this is a question about whether people have paid time off if they can't come to work because of either a kid, because of schools closing, or because of their own illness. So I guess I'll let you kind of take that in two separate questions as you want to.
Right. So prior to Wednesday morning, I would have said the answer to your question is no. But since the Family First Coronavirus Response Act, I'll just call it the Act to be short, there is now PTO available for employees to be away from the office in order to care for their children who are at home due to school closures as a result of the virus. So this
stop you for 1 second, and will you tell us what the Act is and what it means? And
absolutely.
All the things.
The Family First Coronavirus Response Act was recently signed by President Trump. So it is law. It doesn't take effect until 15 days after the law was signed. But what it does is provide a lot of protections for employees, which I know a lot of people out there will be happy to hear. One of the protections that it clearly provides is paid time off for an employee who has to stay home to care for a child over the age of 18 who is at home due to a school closure. So previously, an employee would have to use their own PTO if they have any banked or if their employer has provided them some additional PTO, or the employee would have to take unpaid leave under the Family Medical Leave Act if they qualify. So they have to have a certain number of employees at the workplace. They have to have been there a certain number of months. They also have to have worked a number of hours. An employee was previously restricted to only those options for being away from work to care for their children. But with this new act, they're provided with paid time off in order to do so. So this is up to 14. So this is a 14-day period of time that is paid at a percentage of their wage, so not 100%. And there is a cap, so it's not available indefinitely, but it is something that employees can use right now in order to be home to care for their children. The second half of that question asks whether an employee can use PTO due to their own illness. So some employers had policies that allow you to use PTO only for vacation, and you had to use sick leave only for an illness. So prior to this act, you were restricted once again. If your employer had afforded you some sick time, you are able to use that. If the employer simply gives you an X number of days per year and you can use them in any way, shape, or form, then yes, you could have used it for your own illness. But with the new act, there is now a paid family leave that would allow you to stay at home and receive a portion of your salary for your own illness. So not just being diagnosed with the illness, but having symptoms as well. So this act is a welcome reprieve for employees. Employers might be concerned about how they're going to pay for it, but the act does provide some tax credits to offset the cost to employers.
How do I get those tax credits?
Well, you have to qualify, Matt. So one of the biggest qualifications that's new and unique to the FMLA is that you need to have under 500 employees. So a lot of the big companies out there, this would not apply to them at all. So this is really focusing on small businesses who are feeling the squeeze. They can apply for tax credits in order to pay for this additional paid time off they're required to provide.
All right, Austin, I have many follow-ups for you. I think people are sad. So the question is, are there other types of insurance that might end up picking up these losses that you've not mentioned? Maybe I can more directly ask this question. What other options do we have for covering some of these losses that we're incurring mainly as businesses, either in terms of just like lost productivity, having employees who are sick and losing half of our workforce? What other options might we need to be looking at to potentially have coverage?
Well, I think that question really is some kind of variant of what other risk management solutions do we have, maybe outside of a typical insurance portfolio. It's going to be really interesting to kind of piggyback on what Sheri just was talking about is what is the government going to do right now? So right now there's a bunch of loans available under the Small Business Administration and the federal government that's going to be basically loans that are guaranteed by the federal government at 3 or 4% that are going to be able to apply for, businesses can apply for to make up for these losses, to kind of get them back to zero. I think you're going to see a large amount of borrowing in order in the short term to kind of make up the difference. And I think, from kind of a macro level, we're going to see a bit of a downturn. And if this thing goes into the summer, we could see kind of a more dire situation where you're going to see, not just insurance claims, but kind of bankruptcy counseling and that kind of angle for businesses kind of tend to heat up. I'll tell you to kind of wrap back to your original question was, are there other types of insurance that could pick up here? And there are. So there are more specialized coverages that I think are going to be products that larger kind of insureds or larger companies have. Some cyber policies may pick up if there's an interruption in service. There's also a lot of crime policies right now that pick up for data breaches and then apply to those kind of losses. I think, again, for each business, you're going to have to really take a moment to evaluate what policies you have. And then going forward, one of the keys out of this is not just today, but it's how would I protect myself if I knew this was going to happen 3 weeks ago? What would I have done differently? And I think that's kind of the post-mortem of the situation is evaluating that. But for the smaller businesses that I imagine have commercial general liability coverage, I imagine are going to have property policies. I'm going to be very interested to see how much director and officer claims we see. I think there's a lot of claims. So it's the idea that in a corporation that directors and officers have made decisions that may be adverse to the company, may be adverse to the shareholders. And what I'm really talking about is, did COVID-19, did this pandemic, did you act reasonably as a director or a CEO? And if you didn't, if you harmed stock price, if you harmed your investors in a way that was unreasonable or more than negligent, then I think you're going to see claims against those corporate officers. And there's different kind of insurance called director and officer insurance that may provide coverage for some of these suits and some of these losses.
Okay, so I care a little bit about the business owners, but I feel like a lot of the people watching this are individuals, and so I'm going to flip the question here for you. And like, is there any kind of insurance that I can personally buy to basically protect myself in the future? Because, like, for example, paying my mortgage, buying groceries, having to be quarantined, and the increased cost of paying people to bring stuff to me. Is there insurance that I could have bought, or that some people might have, that would cover this kind of stuff?
That's a great question, Matt. I think the question you're asking is there pandemic insurance? And I think the short answer is there are some incredibly specialized products out there that apply to huge infectious disease issues, but those are only going to be applicable to very large businesses. They're incredibly expensive policies to buy, for an individual, it would be very, very expensive. So I think it's cost prohibitive for most businesses and individuals, but I definitely understand where you're coming from, and I wish there was better news on this front.
All right. So Sheri, so let's say that I am an employee and I am being forced to work from home, and I'm running out of printer paper, and I'm running out of markers, and I'm running out of basically everything related to or for example, I'm on a minutes plan with my cell phone, and I'm having calls that are forwarded to my cell phone, and I'm incurring larger bills for using my cell phone for work purposes. Do employees have any rights for reimbursement of that kind of stuff? Like, who's paying for these home offices that are suddenly being set up overnight?
So I'll start off with what the law says, and then I'll end with best practices, as I've been doing, because that's realistically how this works. So generally, the Federal Labor Standards Act does not allow an employer to collect a reimbursement for teleworking. So if the employee is teleworking and does not allow the employer to require the employee to pay for the teleworking equipment. So when I'm talking about equipment, I mean things like paper, printer, perhaps your internet access, those expenses that could add up if you're teleworking over a period of time. The reason the FLSA does not allow the employer to do that is because if you add up all the expenses, it could cause the employee's wages to fall below minimum wage. So if you do the test, you ask the employee for all their expenses, and you look at their wages on the other hand, if they're still making at least minimum wage, then fine, the employee can pay for the expenses. But if those expenses are causing the employee's wages to fall below minimum wage, and then no, the employer cannot collect a reimbursement. Basically, the employer has to pay for that equipment, and whatever expenses go along with it, the employer would simply be on the hook for it. I should add, though, that the ADA does allow the employer to let the employee telework as an accommodation. So if I have a disability, and on top of my disability, I have COVID-19, and I go to the employer and I ask for an accommodation, hey, I can't work at the office, this is too risky based on my disability, I could catch COVID-19, or I have symptoms of COVID-19, and the employer allows the employee to telework as an accommodation, and then the employer must pay for those expenses. So the employer must pay for the paper and the internet access and everything else that's required.
Okay, so every year when I file my taxes, I also see this little box that says unreimbursed employment expenses. Can some of this stuff that let's just say, again, I just have to presume that the employer is a jerk for some of these questions. Presume that my employer is a jerk and doesn't want to reimburse me for all of this stuff, and I'm having to buy a printer and I'm having to buy a new laptop just to do my job. Can I at least deduct that on my insurance? On my taxes?
Well, I won't even try to answer a tax question. So you're going to have to talk to your tax professional about that. But I can tell you whether or not the Labor Standards Act would require reimbursement or whether the ADA wouldn't. And generally, the employer should be footing the bill. And I did say I would talk about best practices. So just to close with that, for all the employers that are listening, your main goal is always your bottom line. Not always your bottom line, but you always have to consider your bottom line. You have to consider your productivity, you you have to consider your business objectives. And in making those considerations, you're thinking about the well-being of the employee as well as the well-being of your workplace. So if an employee is being burdened by these additional expenses, perhaps their ability to telework will be hindered, and thus they will not be producing the best work. I can think of many employees who are teleworking 100% of the time, and they're enjoying that process because of the equipment that the employer has provided, because of the fact that they know that they will be reimbursed for getting the fastest internet, or for having to use all this new equipment and video and sound in order to be there for virtual meetings. So talking as a practical matter, the employer should really consider whether providing the employee the best equipment and without fear of the costs would allow the employee to produce their best work, which at the end of the day is what we're all trying to accomplish as business owners and employees.
All right, so it sounds like there's going to be some actual hard costs that we incur, and some of them may be reimbursed by the employer. Some of them might be tax deductions, but some of this just might actually just be you're out of luck. I mean, is that fair?
Yes, that is fair. As always, it's a fact-specific inquiry. You ask why they're teleworking, you look at the laws that apply, and make that determination. An attorney can always assist you, however.
I got it. All right. So, yes, this is okay. This is one of my favorite questions here. All right. So, let's say that a business comes in and is selling toilet paper or Lysol or whatever, and it was $4 yesterday and it's $40 today. Yes, that is price gouging. Yes, that is illegal. Yes, that person is probably subject to some sort of criminal charges. If it's a business there and it's a business that is in Georgia, they may also be subject to some sort of civil claim. Georgia has relatively weak consumer protection laws, but even the weak protection laws that Georgia has would probably kick in and protect consumers in this situation. I don't mind giving an absolute plug here for myself. If that happens to you, please call me. We would love to sue that business and help make certain that that business gets a visit from the proper authorities so that it doesn't happen to people in the future, because this is where people actually die, is when you need necessities, when you need to have resources available to you and they're not available because the price has gone up by 10 times as much. That is illegal. It is actionable. If that's happening, call 911. Let me rephrase that. Call the authorities, call the non-emergency line so that they know that it's happening, because the police will probably want to pay a visit to that business at some point. All right. All right, so let's say that someone, okay, so I think we've already had a variation of this question. So what are my rights with respect to overtime pay if I'm forced to work extra hours? So, I mean, is this just a question related to salaried versus unsalaried employees?
Exactly. So if you are not exempt, you're working over 44 hours, you're entitled to overtime for every hour you work over that. And if you are an exempt employee, then you wouldn't be entitled to overtime. We have touched on that a little bit.
Can your employer make you take care of suspected patients against your will? So let's say that this is a healthcare provider and they're being forced to work in a practice and take care of COVID patients. Do they have any options or rights? Is this any different than, say, someone in an office environment?
Yes, it is. So as we mentioned, OSHA has divided workplaces into 3 categories: the high risk, the medium risk, and the low risk. So if you're caring for COVID-19 patients, you're probably in a high risk workplace. In that scenario, OSHA has a comprehensive guideline for PPE, which is personal protective equipment, that you're supposed to have in order to do that work. So as long as the employer has provided that personal protection equipment, as well as other measures, for sanitary conditions, masks, whatever the guideline has the employer needing to provide in order for you to work safely, then yes, there would be a good argument that you are required to continue doing your job. If any of those personal protective equipment is not present, and then it becomes an unsafe workplace, and you could have a right to refuse work. But if the employer is sticking to the guideline provided by OSHA, and as well as the CDC in providing all the equipment that's necessary, there would not be a good argument that it's an unsafe workplace, and you would have to keep working. Uh-oh, I've lost you again.
All right, so here's another question for you. So let's say that I'm a business owner and we have to lay off employees. Are we required to pay the 2 weeks of sick pay before they can begin collecting unemployment? And then what about if well, answer that question first. So let's say that I'm having to lay off employees. Do I have to give them 2 weeks of sick pay before they can begin collecting unemployment?
Okay, so I'm guessing, well, I shouldn't guess, but it sounds as though that question is referring to the Family First Coronavirus Response Act, which provides for the 14 days of paid sick leave. So I think the caller or the asking whether they have to allow the employee to use that statutory protected time before the employee goes on unemployment. And to answer that question, really, if you're closing your work space or you're shutting down your business entirely, then they would not have the opportunity to take that 2 weeks paid leave before you shut down. You would not be required to keep your business open for 2 weeks to allow them to use those benefits before going on unemployment. And I think what you mean by going on unemployment means laying the employee off. So to answer your question briefly, no, I believe that you would be able to close down your workplace if that's your intention, and then the employee can collect unemployment insurance. If you're not intending to close your workplace, then yes, they would be entitled to apply for that 14-week PTO, and you would have to provide that. I think I've answered the question. I think the caller's going about that.
I got 2 follow-ups here. So one is, what if they've already used their paid time off, or they have less than 2 weeks? What are my options?
Well, if you are a covered employee or under this new act, the Families First Coronavirus Response Act, and then you would have to give them additional paid time off. So the act gives the employee the discretion to choose whether they want to burn through their banked PTO or whether they want to use the Act's 14-day paid sick leave provision first. So the employee gets to make that choice. In older versions of the Act, it was a little bit different, but the employee can choose. So you basically would not have to, as the employer, you wouldn't get to make the decision. The employee gets to make that decision.
Is there a best practice here? Like, I mean, let's say that I'm a normal employee, I've got banked time off. What if I'm given the choice as either an employee or an employer? Is there one that's better than the other? Like, what do you recommend here?
Well, a lot of employers are concerned about the liability that banked PTO has. So there are many ways that employers manage this. Some will have a cap saying that you need to bank X amount, after which you just forfeit them. Some employers will prohibit hours from rolling over from year to year, because that is a cash liability that employers are concerned about. So if that's your concern, you may prefer that the employee use those PTO hours first before they use this new protected leave. So that may be the preference of the employer. You just need to determine what cash liabilities you have on hand yourself. But generally, employers do prefer employees to use all their paid leave first, all their banked paid leave first, before anything else.
All right. So this one might be a little specific, but I'm going to ask it because there may be other people in the same situation. So let's hypothetically, let's say that someone signed a contract to begin a new job, and then they resigned their old job, and then the new job says, thanks to COVID, we cannot employ you anymore, and now they've lost their job, and they have no jobs left. Do those people have any rights, or, I mean, what can that person do, if anything?
Well, if the new job offer was not a contract saying, I promise to employ you for 12 months, then you would have no recourse, because if they are in Georgia, they're an at-will employer, they can terminate you for any reason or no reason, as long as it's not an illegal reason. So if they've given you an offer and then retracted it because of COVID-19, I can't think of a claim that you would have unless you have an employment contract that says you need to hire me for this term. And if they cut you off before that term ends, then you could have a breach of contract claim. Barring that, unfortunately, that is an unfortunate circumstance, but I don't know what kind of recourse the employee would have.
All right. So we're kind of coming to the end of the hour here. There are other questions coming in, but for the most part, these seem like things we already covered. So a couple of things is, one, that this will be broadcast on YouTube, and you will be able to watch it from the beginning at any point. So you can see this from the start if you missed some of the earlier questions. If you have additional questions that you feel like weren't answered, you can reach out to me directly. And so we'll go around here in just a second and make sure that everyone has an opportunity to give you their contact information so you can ask them a question directly. My name is Matt Wetherington. You can reach me at matt@wfirm.com. So if you have a question, I'm always happy to answer it. I primarily handle personal injury and wrongful death and class action claims. If you're asking an employment question, I would absolutely send you to Sheri. And so, Sheri, can you tell people how they can get in touch with you if they have additional questions?
Sure. So my name is Sheri Oluyemi. I'll spell my Nigerian name for you. It's Oluyemi. And I can be reached at 404-500-6202. And my website is www.losollc.com. And I do exclusively.
Right. Hang on one second. Give me that one more time, and I'll put it up on the screen. What is the website, you guys?
The website, it's www.losollc.com.
Boom. All right. I've got you there.
losollc.com.
LLC. Whoops.
That's the one.
All right. Hang on. That is wrong. How about now?
Perfect.
All right. Perfect. And if I'm an employee, can I still call you?
Yes, you can. I do serve employees as well. I serve professionals here in the city of Georgia. I'm happy to help.
All right, fantastic. All right, Austin, tell us how to get in contact with you, as well as kind of why someone might want to call you.
Thanks, Matt. My name is Austin Bersinger, and you would want to call me if you have an insurance issue where you were trying to make a claim that was related to COVID-19 and you wanted the carrier to honor their coverage. So if you're a Georgia business owner, my practice is exclusively insurance recovery for Georgia business owners. If you wanted to get in touch with me, the best way is probably you go to my website. It's bersingerlaw.com. You could call our office. Our office is still open. It's 404-965-3692, or just because we're all pretty digital creatures now, Austin@bersingerlaw.com. That's my email. So I'm happy to just give a consult on an insurance issue and to be mindful that right now there's going to be so many opportunities where you have a claim and we're all going to suffer some kind of loss as business owners, and insurance should be part of your risk management portfolio. And if I can be helpful to you in pursuing your insurance coverage, I'm happy to do that. Thanks, Matt.
Last question for both of you. Does it cost anything to get a phone call with you or to ask a question? I don't mean to put you on the spot.
Absolutely not. I do take free consultations. Give me a call.
All right, sounds good. How about you, Austin?
First call is free.
Absolutely. All right, thank you, guys. If anyone else has additional questions, feel free to shoot any of us an email. And thanks for tuning in, and I hope everyone has a great day. And stay safe out there.